The use standard is not what applies to making something public or private.
Are those walkways considered common elements?
Absolutely.
Okay, so you have support from a statute, don't you?
Absolutely.
46(8)(b)(14 that says the association is responsible for the maintenance, repair, replacement, cleaning, and sanitation of the common elements.
That is correct, and it's undisputed.
So is that where the appellate division may have gone wrong by equating this sidewalk with a public sidewalk merely because members of the public might walk on it?
That's exactly where they went wrong. They focused on the use and not the ownership. A sidewalk does not become public, nor does it become private based on the use. If a public sidewalk in Luchenko, in Hoboken, is 99% used by the residents of the association, that doesn't make it a private sidewalk.
No.
It's still a public sidewalk.
Right. In Luchenko, when the court, in its opinion, was talking about the need for certainty and continuing with a line of cases that had been followed that had a distinction between commercial and public, there was no question that those sidewalks all were public sidewalks.
That is absolutely correct.
That were being exempt.
Absolutely correct.
And
Now,
the public sidewalks owned by the municipality.
once again, that's the position we have taken from day one.
Luchenko, the sidewalk was owned by Hoboken, correct?
That is absolutely correct.
Now, what duty of care is owed then by the HOA to people who are using their walkways?
To standard duty of reasonable care, and that's a question for the jury. Standard duty of reasonable care to maintain and operate that sidewalk in a safe and reasonable fashion for the people who are intended to use
Well,
it.
how does that square with the statute, 62A13(2A)?
As far as,
It says immunity, whereby the bylaws of a qualified common interest community specifically so provide. Shall not. Are you familiar with the statute?
I am.
Okay. The second part says, nothing in this act shall be deemed to grant immunity to any association causing bodily injury to the unit owner on the premises of the qualified common interest community by its willful, wanton, or grossly negligent act of commission or omission. So,
not grant immunity.
right. So the question is whether or not the bylaws provide for immunity.
These bylaws do not provide for
Okay.
immunity. There is an exculpatory clause as it pertains to homeowners. Whether or not that's binding or not is another issue for another day. My client was not a homeowner.
So what does that say, that the exculpatory clause?
I believe under the bylaws, homeowners who are owners of unit owners in fee simple, they may have signed an agreement where they may have agreed.
And that would not apply to their lessees?
Well, my client was not a lessee, she was a resident. Whether or not it would apply to a lessee, I think unless they signed the actual agreement, I don't think it would apply. It would really depend on what they sign as the lessee.
So you said the duty of care extends on the part of the homeowners association to the individuals intended to use the sidewalk. So your client would be covered as somebody who owns property in the association. What about somebody walking their dog?
Well,
A non-member.
Like Justice Alban had said, unless there's a sign that says no trespassing or they're deemed a trespasser, that's a different standard of care. If this is an open community and Johnny wants to walk his dog through the development, I suppose he has the right to do that. His definition of how he is there, invitee, licensee, would be subject to the facts of the case. I don't think there's anything that prevents him from doing that. I don't see it as a difference for purposes of the obligation and the duties that the homeowners association has agreed to be bound by its bylaws.
Didn't the HOA in this case have immunity from any claims by owners absent willful or wanton or gross negligence?
Under the bylaws, that is true for homeowners.
And your client was an owner, correct?
Was not an owner, no. Her son had purchased the property. It was not in her name. She was simply a resident of the property. So she's not barred under that, and nor has anybody taken that position from the defense.
There's nothing preventing a homeowners association from putting up signs that, people who are not guests or welcome on the property or not permitted to trespass on the property.
They have the right to put those signs up, and they have not. They have the right to make it a gated community if they so choose to, if that's a concern that they have. I think to get a flavor for the type of complex this is in Plainsboro, New Jersey, different from, say, Luchenko in Hoboken, which was a high-rise tower. This is a 35 or 40 acre development throughout Plainsboro, New Jersey. There are sidewalks, common sidewalks within the community throughout the development.
How about the roadways? Are the roadways turned over to the community, or are they private roads?
At the time of this, I do not believe the streets had been dedicated they were still owned by the HOA. This development was still under construction. I don't think Toll Brothers had even sold all the units. I think, say there were approximately 100 units. Maybe they had sold 75 or 80 at that point in time.
Has there been a dedication since?
That I'm unclear of. As to
But
the
no dedication as of the time?
No, there
The
is not.
35 to 40 acres, is there one way in and out, or are there multiple streets that take you in and out of the community?
Well, there are once you're in the development, there are multiple streets that will eventually get you out. The only entrance and exit I am aware of, and at most there may be two, the one I'm aware of is the one my client was going towards to get to the supermarket to buy some food. The testimony I had was she was in the house for about 2 days following a snowstorm and she needed to get some food. I know of that entrance and exit. There may be one more, but I don't think more than that.
Do you know who's responsible to fix a buckwing public sidewalk in front of a residence?
Public sidewalk?
Yeah, public.
In front of a residence.
Yeah,
I would expect that would be the township
okay.
or the borough.
Whereas it's clear, obviously, when you're dealing with a private walkway, common elements, the homeowners association has that.
Absolutely. And one of the points I wanted to make was hypothetically, my client had indicated that on the 19th when there was a snowstorm through the 21st, she couldn't leave her house because not only were the sidewalks not snow plowed, but the driveway and the walkway to her home, which is also under the bylaws required to be maintained, were not done. In a situation where a resident or a homeowner decides after 2 days or so nothing is done, what are the options that are available to these residents or homeowners? What can they do? I suggest that if on my private residence, if I decided I needed snow removal done, I can call Acme Snow Removal Service, a landscaping company, to come and do my driveway or my walkways if I choose to. The residents and homeowners do not have that right here under the bylaws.
There's a little bit of democracy going on. You know, they can all meet in one of these town hall meetings and say, hey, we don't want to pay the expense of having people plow the roadways, or we'll take it to 4 inches because
Sure.
it'll cost us less. They can do that, right?
Well, they could eventually do that, and I think the evidence in this case was it was actually correspondence post-accident from the homeowners association where residents did complain and did bring forward the fact that they weren't happy with the manner in which things were being done. And once again, remember, this is a relatively new community. Hadn't even been completed yet. So whether the left hand knew what the right hand was doing as far as snow removal and maintenance, it was pretty clear that 2 days after a storm, nothing had been done, at least to the driveway and to the walkway.
Going
Follow
back,
me-
I'm sorry.
Follow me on this hypothetical walk through a community. You're going to take a mile walk around the town at the end of the day, just get a little exercise. You start in the community, your community, where you own property, and there's a certain duty of care that extends to you on the part of the homeowners association. You then walk over to the store out in public space owned by the town, different situation, and then you walk over to a development hypothetically that Hovnanian has across the way where you're not a member, and there's yet another duty of care and set of rights that might apply as you work your way back to home?
Do I fall on the property within my community?
If
Or
you fell on any one of those three, you're
Well, if I
suggesting
fall-
to us there would be different standards that would apply, is that correct?
There'd be different standards for the public property. If I fall on public property, such as Township of Plainsboro property, then there's a different standard. I'm governed by Title 59.
And if
I'm not completely immune, or I should say there's no complete immunity to the township. There is an immunity under Title 59, but under the appellate division case here, there's complete immunity.
And if you're an outsider to the hypothetical Hovnanian property, there's yet another approach that would apply, is that?
Well, the approach would once again, I think, be pursuant to the bylaws, but also, once again, if it's private property, they have a duty of care to maintain and operate those sidewalks in a reasonably safe fashion. Whether that person is an invitee or a licensee may quite depend on whether they get a recovery or not.
And
But
under
duty-
under
excuse me,
the public sidewalks, residential or commercial dichotomy, you have a different standard of care operating there too, don't you?
Absolutely.
On the
Okay.
same block, could be on the same block.
Well, I don't know if it would be on the same block. It really,
Well, if you had a block that's commercial, residential, commercial,
Sure.
residential, particularly in some of these cities.
well, that would still be, I think, under that standard, still be a public sidewalk, whether it's commercial or residential. That
But
is
that would
true.
that would govern the obligation of the owner to do something with those sidewalks, correct?
True. But under this facts, under the private sidewalk, I think the standard is completely different.